In 30-plus years on the bench, I have seen arrogance walk through my courtroom door in every shape, size, and tax bracket imaginable. I have seen it wearing three-piece suits, and I have seen it wearing torn jeans. I have seen it carrying leather briefcases, and I have seen it carrying nothing at all, just an expression that says the rules of this room are for other people. But every single time, without exception, without a single solitary exemption in 3 decades of jurisprudence, that arrogance has eventually had to sit down across from reality. And reality, I can tell you from personal experience, is not impressed by your inheritance. His name was Preston. And before he even opened his mouth, before he said a single word in my courtroom, he had already made 3 mistakes that I cataloged in the first 60 seconds of his arrival. The first was the smirk, not a smile, a smirk. There is a universe of difference between those 2 expressions, and anyone who has spent time reading human faces knows exactly what I mean. A smile opens, a smirk closes. A smirk is the face of a person who has already decided that what is happening around them is slightly beneath their level of engagement. It is the facial equivalent of checking your watch in the middle of someone else's sentence. The second mistake was the way he looked at my courtroom. Not at me, not at the plaintiff standing at the other podium. At the room itself, the way someone looks at a restaurant that got a worse review than they expected, like he was cataloging its inadequacies, like the institution of justice assembled in that room with its protocols and its oath and its centuries of accumulated purpose was a mild disappointment he was graciously agreeing to participate in. The third mistake, and this is the one that told me everything I needed to know about how this was going to go, was that he laughed. Not at anything in particular, just a small, quiet, almost private laugh, as if a thought had occurred to him that he found amusing in my courtroom before the case had even begun. That laugh lasted approximately 2 seconds. The silence I gave him in return lasted considerably longer, and it carried considerably more weight. He was the defendant, being sued by his former personal assistant, a woman named Gloria, who had worked for his family for 11 years, for $3,200 in unpaid wages and reimbursable expenses. $3,200. To Preston, that was probably what he spent on a weekend. To Gloria, standing at the other podium in her sensible blazer, with her careful handwriting on her printed documents, it represented months of work that she had simply never been paid for. And Preston found it amusing, right up until the moment he didn't. And that moment, the precise, specific, surgical moment when the amusement drained out of his face like water out of a tub. That is what this story is actually about. Let me describe Gloria to you first, because understanding the contrast is essential to understanding the case. Gloria was in her mid-50s. She had worked for Preston's family since before Preston was old enough to have opinions about anything, which made the particular brand of condescension he aimed at her even more revealing than he realized. She wore reading glasses on a chain around her neck. Her documents, and I mean this as the highest possible compliment in my courtroom, were organized the way honest people organize things. Not to impress, not to overwhelm, but to be useful. Her receipts were in chronological order, paper-clipped, with handwritten totals at the bottom of each section. She had a small notebook where she'd recorded dates and conversations in the neat, compressed handwriting of someone who had learned early in life to take notes, because no one was going to remember things on her behalf. She looked tired, not dramatically tired, not performing exhaustion for my benefit, just genuinely, quietly tired, in the way that people get when they have been doing the right thing in a situation that keeps rewarding the wrong one. Preston, on the other hand, came in with what I can only describe as curated casualness. His clothes were expensive in the way that requires a specific kind of education to recognize. Nothing with a logo visible, nothing that announced itself Everything simply and quietly correct in the way that enormous amounts of money can make things correct. He had no documents that I could see initially, just a phone that he glanced at twice before I addressed him directly, and a sort of ambient confidence that I imagine had served him extraordinarily well in rooms where it went unchallenged. My courtroom is not that kind of room. He opened his defense the way people of his particular disposition often do, not with facts, but with framing. His position was that Gloria's claims were, and I want to give you the exact texture of his language because it matters, not how our arrangement worked. Not that she was lying, not that the expenses didn't happen, not that the hours weren't logged, just that her version of what she was owed was inconsistent with his understanding of their arrangement. He said that word, arrangement, with the particular inflection of someone who believes that the informality of a relationship excuses them from the obligations created within it. I've heard that argument more times than I can count. It is the argument of people who prefer verbal agreements precisely because verbal agreements are difficult to enforce and easy to reinterpret after the fact. It is the argument of people who have never had to worry about what happens when the other party to the arrangement stops finding it agreeable. He told me Gloria had been generously compensated over the years. He told me his family had given her bonuses, though he couldn't specify when or how much. He told me that the expenses she was claiming were personal decisions she made on her own initiative that his family had never formally authorized. He said it all with a fluency and an ease that suggested he'd rehearsed it, though not quite long enough to iron out the fundamental problem at the center of it, which was that Gloria was sitting 4 feet away from him with receipts, actual, physical, dated, detailed receipts. I let him finish. I gave him the full runway. Because in my experience, the runway is where people accelerate fastest toward the wall they're about to hit. Now, I want you to understand something about how I work because it's relevant to what happened next. I do not interrupt litigants because I'm impatient. That's a misconception. I interrupt them when they've said something that requires immediate correction, when they're misrepresenting something so brazenly that allowing it to continue would constitute a disservice to the truth. But when someone is in the process of building their own trap, I have learned, through decades of watching exactly this, that the worst thing you can do is stop them. Let them build it. Let them furnish it. Let them walk inside and close the door behind them. Then ask them how they got in there. So I let Preston talk. And I watched what I was watching for specifically was the moments when his performance of confidence and his actual experience of the situation didn't quite match up. And they're always there in people like Preston. They just require patience and attention to find. His tell was subtle. It wasn't the obvious tells of the amateur liar, the eye shifting and the excessive blinking and the touching of the face. Preston was smoother than that. His tell was a kind of brief, almost imperceptible recalibration that happened in his expression whenever a question landed somewhere he hadn't prepared. His face would do something, not quite freeze, more like pause, the way a screen pauses when it's buffering, and then the fluency would return and he'd continue. But that pause was there. And every time I saw it, I knew I'd found another edge of the territory he hadn't mapped. I asked him about a specific set of expenses that Gloria had documented, travel costs she had incurred while managing logistics for a family event. He said those were personal expenses that had nothing to do with her role. I asked him what her role was precisely. He described it in general terms: scheduling correspondence, managing household vendors. I asked him if managing logistics for family events fell within that description. He said it depended on the event. I said the event in question was a birthday party for your mother. Did Gloria organize it? He paused. That specific pause I mentioned. Then he said she had assisted with it. I said, did she travel to coordinate vendors for this event? He said she had, but that the travel was at her discretion. I want to stop right here and explain something to you, because at her discretion is a phrase that requires a particular kind of unpacking. When an employer sends an employee to do a task and the employee travels to accomplish that task, the travel is not at her discretion in any meaningful legal sense. Her discretion was whether to take the job. Once she took the job, the expenses incurred in performing it belonged to the employer. This is not complicated. This is not ambiguous. This is the kind of thing that is covered in the first week of any employment law course, which Preston had presumably not taken, because his family's money had ensured that his education consisted primarily of things more enjoyable than employment law. I let him believe I was satisfied with that answer. I moved on to something else, and I watched him settle back into his comfort, the recalibration completing itself, the smirk returning just slightly at the edges. He thought he'd navigated something. He had, in fact, just finished furnishing the room I was about to lock him inside, because here's the thing about letting someone talk past the point where they should have stopped. They don't just give you their argument. They give you their assumptions. They tell you what they think you don't know. And what Preston thought I didn't know was sitting in Gloria's neatly paper-clipped stack of receipts in the quiet, careful handwriting of a woman who had kept records for 11 years because she always suspected that someday she would need them. There is a specific kind of silence that happens in a courtroom when the balance shifts. Not a loud silence. If that sounds contradictory, I assure you it isn't. It's the kind of silence that has weight to it, the kind that people feel on their skin. I've produced that silence hundreds of times, and I will tell you that the mechanism is always the same. You ask the question you've been holding since the first 10 minutes of the case, and you ask it at the exact moment when the other person is most certain they're safe. I picked up one of Gloria's documents, a printed email chain time-stamped from a date approximately 14 months before the case was filed. I read it silently for a moment. Then I looked up at Preston. I said, "Do you recognize the email address that sent the message dated the 14th? He looked at the email I was holding up. He said yes. It was his assistant's email, meaning Gloria's professional email address, the one his family had set up for her and paid for as part of her role. I said, "And in this email, Gloria is requesting reimbursement for the travel expenses we just discussed. Your mother's birthday party. She is itemizing the costs and asking for reimbursement. Do you see that?" He said yes, though his voice had lost some of the easy fluency it had carried for the past 20 minutes. I said, "And below her message is a reply from your family's estate manager, not Gloria. Someone else in your family's employ, confirming that the reimbursement had been approved and would be processed. Do you see that?" The pause this time was not brief. It was the kind of pause that fills a room. His eyes went to the document, stayed there, came back to me, then went back to the document, which of course he couldn't read from where he was standing, but the act of looking at it was its own kind of confession. He said, "I wasn't aware of that specific communication." I said, "You weren't aware that reimbursement for the travel expenses you just told me were at your employee's personal discretion had been approved by your family's own estate manager." He said his family employed many people and he wasn't personally involved in every administrative communication. I set the email down. I took off my glasses because I want people to understand when I am moving from the examination phase to the conclusion phase. And taking off my glasses is how I signal that. And I looked at him with the kind of directness that does not require volume or theatrics to carry its full weight. I said, "So let me make sure I understand your position. You told me these expenses were Gloria's personal choices made at her own discretion, for which your family bore no responsibility. I am now looking at a document from your family's own estate manager. your family's representative explicitly approving reimbursement for those exact expenses, not disputing them, not questioning them, approving them, and your position is that you weren't aware. He started to speak. I raised one finger, just one, barely shoulder height, and he stopped. I said, "Let me ask you something much simpler. If your family's estate manager approved reimbursement for these expenses 14 months ago, why is Gloria standing in my courtroom today asking me to help her collect money your own family already agreed she was owed?" That question sat in the room like a stone dropped in still water. The ripples went all the way to the walls. Preston looked. For the first time since he had walked through my door with his smirk and his expensive casual clothing and his quiet private laugh, genuinely uncertain. Not uncertain about the facts, he knew the facts. Uncertain about what was left to say when the facts had been so precisely and completely arranged against him. But then, and this is the part I want you to pay very close attention to, because it is the moment that earned him what came next. He tried one more thing. He straightened his jacket. He lifted his chin, and he said, "I think there may have been a miscommunication within our staff. That's not something I can be held personally responsible for." Miscommunication. After everything, after the email, after the approval, after 11 years of Gloria's service to his family, after $3,200 that she had worked for and documented and requested properly and been approved for and still never received. His answer was, "Miscommunication within the staff. I've been doing this for a very long time." Very few things in that courtroom genuinely surprise me anymore. But the audacity of using staff dysfunction as a shield after you spent 20 minutes telling me the expenses were never legitimate in the first place. That particular maneuver still has the power to make me lean forward in my chair. And I leaned forward. I want to tell you exactly what I said, and I want you to hear the temperature of it, because this was not a moment for shouting. Shouting is for when you need to cut through noise. In that moment, there was no noise. The room was completely still. Every word I said landed in absolute silence, and I chose each one with the precision of a surgeon who has been doing the same procedure for 30 years and has not once nicked anything they didn't intend to. I said, "You came into my courtroom today and you mocked it. You didn't do it loudly, I'll give you that. You were subtle about it. The laugh when you walked in, the phone you checked twice before I'd said a word. The way you described your employee's legitimate business expenses as personal decisions she made on her own initiative, when you had an email from your own family staff approving those exact expenses sitting in the record. You mocked this courtroom and you mocked the process, and most significantly, you mocked this woman who worked for your family for 11 years and is standing here today asking for $3,200 that your own people agreed she was owed. I let that breathe for exactly as long as it needed to. Here is what your inheritance did not buy you, Preston. It did not buy you the ability to rewrite what happened. It did not buy you the right to decide retroactively that obligations your family created don't count because you weren't personally copied on the email, and it did not buy you the experience necessary to walk into a room and know when to stop talking. That last one might have helped you most today. Judgment for the plaintiff, full amount, $3,200. And I noted for the record that Gloria had demonstrated more professional integrity in the organization of her paper-clipped receipts than Preston had demonstrated in the entirety of his time in front of me. He left without the smirk. I noticed that specifically. The smirk was gone, and what replaced it was something quieter and less legible, the expression of someone who has just encountered, possibly for the first time in their adult life, a consequence they could not charm or spend or socially engineer their way out of. It's a specific look. I've seen it before. I hope for his sake he sat with it long enough to learn something from it. I'm not optimistic, but I hope. Gloria gathered her paperclip documents with the same quiet efficiency she'd brought to everything else in that case, and she thanked me, simply, briefly, without performance, and she left. Now let me tell you what I actually think about cases like this one, because the $3,200 is almost beside the point. Cases like this one are about something much larger and much more corrosive than one person failing to pay another person's expenses. They are about what happens when wealth operates for long enough without accountability. When every room a person walks into reshapes itself around them. When every disagreement resolves in their favor. When every arrangement bends to their interpretation because the other party in the arrangement cannot afford financially, professionally, socially to push back. What happens is that the person at the center of all that accommodation stops being able to perceive the edges of their own behavior. Not because they're evil. I want to be very precise about this. But because the feedback mechanism that teaches most people where their behavior ends and other people's dignity begins has simply never functioned for them. Every lesson that should have said, "This is too far," instead said, "You're fine, keep going." Every moment that should have produced consequence instead produced deference. And so they arrive in adulthood, in my courtroom, genuinely, sincerely, not performing it, confused about why the world has suddenly stopped accommodating them. Why the woman who spent 11 years managing their family's chaos and keeping their household running and traveling to coordinate their mother's birthday party is standing in front of a judge asking to be paid. Why the rules that everyone else in the building is following somehow apply to them too. The answer is that the rules always applied. They just hadn't been enforced. And there is a profound difference between rules not applying to you and rules not being enforced against you. Preston had spent his entire life experiencing the latter and mistaking it for the former. My courtroom is where that mistake gets corrected. That's what the bench is for. Not to punish wealth, not to redistribute anything, just to hold the line that the rest of the world, in its various accommodations and social calculations and professional deferences, sometimes fails to hold. To be the room where the question is not who has more power or more money or more of the kind of confidence that comes from never having been seriously challenged. The question in my room is always the same question. It is the only question that matters in a courtroom, and it is the only question that Preston, despite all his advantages, was completely unprepared to answer satisfactorily. What actually happened? Not what you prefer to remember, not what serves your current interest to believe, not what your family's lawyers have helpfully suggested is your strongest position. What actually happened on the ground, in the receipts, in the emails, in the paperclip documentation of a woman who worked hard and kept good records because she knew the way people who have always had to look out for themselves always know that someday she would need them. What actually happened was that she earned it, it was approved, and it was never paid. Everything else was theater. The only thing that surprised me about this case was the laugh. That small, quiet, private laugh he gave when he first walked in. Even for my courtroom, that was a particular kind of bold. I've thought about that laugh since. I think it was the sound of someone who had never, not once, walked into a room and lost, who had confused the track record with the rules of the game. He knows the difference now. That's $3,200 well spent, if you ask me. Possibly the most educational money that family has ever parted with, and Gloria. Gloria went home with what she was owed. It shouldn't have taken a courtroom. It never should have come to that. But it did, and she showed up, and she had her receipts in chronological order with handwritten totals at the bottom of each section, and that was enough. That is almost always enough. Do the work. Keep the receipts. And remember that every room eventually has a bench.